These are the facts. The case involves a dispute between the plaintiffs, who are the registered proprietor and tenant of a house, and the defendant, which is a residents' association managing a guarded neighborhood scheme in the area where the plaintiff's house is located. The plaintiffs filed a claim against the defendant for public and private nuisance and breach of personal data law, seeking various remedies including a declaration that the defendant's security business within the area was illegal and an injunction to restrain the defendant from harassing them. The High Court dismissed the plaintiff's claim, finding that the defendant had not committed any acts of nuisance, had legal approval to operate the scheme, and had not breached the personal data protection law. The plaintiffs appealed the decision, arguing that the approval given by the local authority to the defendant to operate as a guarded neighborhood, GN, was unlawful and without basis, and that the defendant had committed acts of nuisance and breached the personal data protection law. The decision, dismissing the plaintiff's appeal. The plaintiffs had failed to put up a proper case against the defendant based on the tort of nuisance and to prove that the defendant was carrying out an illegal business. The pleaded facts on the tort of nuisance allegedly committed by the defendant were not at all clear, and on the issue of the pleading alone, the claim ought to be dismissed. The plaintiffs' failure to appeal against the whole of the High Court's decision disabled them from mounting any challenge to the High Court's finding in respect of the local authority. By appealing against only a part of the decision, the plaintiffs were deemed to have accepted the other part of the decision and were stopped from arguing issues or points that were contrary to their notice of appeal. The Guidelines for Gated Communities, GC, and Guarded Neighborhoods, GN, had been approved by the National Council for Local Government as a matter of national policy, allowing local authorities to rely on them to approve such schemes, provided that the approval was consistent with relevant laws and regulations. Even though there was no specific legislation on the GN scheme in question, the local authority had the power to approve it based on the general power conferred to it by the Local Government Act 1976. The issues raised by the plaintiffs with regards to the GN scheme, and in particular, the obstruction caused by the setting up of the boom gate, were raised upon the approval of the GN scheme being granted by the local authority. In this regard, the principle of law laid down in O'Keen Ho versus Persatuan Penduduk Taman on a GC scheme applied to the GN scheme. Based on the pleadings and the undisputed facts, the plaintiffs had failed to fulfill the requirements of law under the Government Proceedings Act 1956 to file a claim for the tort of public nuisance, and on that ground alone, its claim against the defendant failed. There was no evidence that the defendant had committed any acts defined as processing under the Personal Data Protection Act, PDPA, while collecting personal information of non-members and visitors to the guarded neighborhood area. Even if the plaintiff's allegations were true, their claim would not be valid under the law, as the unlawful collection and misuse of personal information was an offense punishable under the PDPA, and the plaintiffs should have lodged a report or complaint with the Commissioner. Non-compliance with the PDPA could not be a cause of action in a civil suit. The initial written grounds that were given by the High Court were akin to broad grounds of decision that were delivered on the day of the decision, whereas the second written grounds were the full grounds of judgment after the High Court's decision, the contents of which were only an elaboration of the first grounds. It was not wrong of the High Court to have prepared the second grounds of judgment, in which the High Court had elaborated on the same facts and laws that were raised before her. To know more,